Huzzah and good day, my wonderful students. Today we begin our study of federalism, and we start with national and state powers. Now, the Constitution gave specific powers to the national government. Those are delegated powers, meaning that the states and the people had delegated those powers to the national government. The rest of the powers were reserved or kept for the states. The national government and the states also share some powers. Now, there are three types of national powers: express powers, implied powers, and inherent powers. Express powers are expressed directly in the Constitution. They are also called the enumerated powers. Most of these are found in the first three articles of the Constitution. This includes the power to collect taxes, coin money, make war, raise an army or navy, etc., the ones we talked about before. Now, implied powers are powers needed by the government to carry out its express powers. The basis of the implied powers is the necessary and proper clause. This includes the power to draft people, regulate nuclear energy, and form the space program. For example, it might be necessary for national defense and to raise an army, which is an express power, to draft people into the army. Implied, necessary, and proper. Now, an inherent power is a power that a government has because it's a government, even though they're not necessarily covered in the Constitution. This includes immigration and diplomatic relations with other governments. Now, the Supremacy Clause, Article 6, Section 2 of the Constitution says no state law or state constitution can conflict with national laws or the national Constitution. State and local officials must support the Constitution. They must agree to uphold and defend it. Concurrent powers are shared powers. These are powers given to both the states and the national government. This includes the power to tax, to maintain courts, to define crimes, and to appropriate private property for public use, eminent domain. Now, denied powers are powers that are denied to the national government. The national government cannot tax exports or interfere with the states doing their duties. The states cannot make treaties with foreign governments or grant titles of nobility, which is why I am not Lord Stone of Willsborough. The Bill of Rights also limits what the states and the national government can do. Republican form of government. This doesn't mean a form of government that has a Republican Party. This means a form of government that is a republic. The national government must guarantee that each state has a republican form of government. So there is no nobility, there is no dictator of New York State, etc. This section was used at the end of the Civil War to force the southern states to ratify the amendments giving former slaves citizenship, with the idea being that if the former slaves were not considered citizens, then the form of government the southern states had was not a republic. Now, protection. The national government must protect the states from invasion and domestic violence. Now, domestic violence has also been interpreted to mean natural disasters, such as a hurricane or an earthquake, or maybe even a widespread pandemic virus. This allows the national government to send troops to help disaster victims and to provide disaster relief in the form of money and other services. Territorial integrity. Now, this is important for what I'm going to talk about in the next slide. But the national government cannot use territory that is part of an existing state to create another state without that state's permission. So we can't carve off, say, the section of northern New York and create another state without New York State's permission to do that. Now, this has only happened twice in U.S. history. The first one was Maine, which used to be part of Massachusetts, was separated from Massachusetts with Massachusetts' permission to provide an additional free state during the time before the end of slavery in the Missouri Compromise, so that a free state and slave states would remain equal. The other time was in West Virginia and Virginia. During the Civil War, the counties of West Virginia voted to secede from Virginia, and they became their own state even when the war was over and Virginia came back into the Union. Now, in order to admit new states, it starts with Congress. There are two limits: the territorial integrity, which I mentioned, and a possible presidential veto. So what happens is this: an enabling act is passed by Congress that would allow a territory to become a state. Then the territory must prepare a constitution for it to become a state. Then that constitution must be approved by a popular vote of the people who live in that territory. So if Puerto Rico wanted to become a state, Congress would pass an enabling act, and then Puerto Rico, a territory of the U.S., would then write a constitution for itself, and then the people of Puerto Rico would have to approve that constitution. And then it's submitted to Congress. And then, if Congress approves, then it's sent to the president. Now the president can sign it, and then in which case it becomes a state. But if the president vetoes it, then it goes back. Congress or the president may put conditions on admission of a territory as a state into the U.S. For example, President Taft vetoed Arizona's admission to the Union until changes were made to Arizona's constitution, which is a really funny thing, because what he did was he wanted them to take 3 provisions out of their state constitution. So they did that, and then Taft decided, okay, now you've taken those out, great, and he signed it, and they became a state. Well, all the states are also equal to each other. And so because they're all legally equal to each other with no extra privileges or responsibilities, as soon as Arizona was a state, they immediately went back and amended their constitution and put those 3 provisions back in that the president didn't want. And there wasn't anything Taft could do about it because the president has no control over what a state does to its constitution as long as the national government is supreme and the state still has a Republican form of government. Each state is legally separate from every other state. They don't have to be the same. Now, the National Governors Association was basically created when President Theodore Roosevelt called the governors together to discuss conservation, because Roosevelt was somewhat of an early environmentalist. Now, the NGA continues to meet and influence national policy. Through the years, in the 1970s, the NGA focused on helping governors in their own states. In the 1980s, however, it became more focused on national policy concerns such as national education, welfare, healthcare, etc. In 1989, various educational initiatives were started. Now, the states conduct and pay for all the elections of all national government officials, which is why we don't have a national voting system. Well, while some people might say, well, that's really not a good idea, it makes things more confusing, and certainly they have a point, the other side of it was that because the states control the elections of all national governments, that means that no one group can get in charge of the national election, because there is no national election, and then decide who's going to be in charge. It's again part of that separation of powers, preventing one group from becoming too powerful. And no amendment can be added to the Constitution unless 3/4 of the states approve it. So this balances out, again, power of the national government and its supremacy. But at the same time, the states have rights as well. The Supreme Court. Divisions of power can blur lines of responsibility. The Supreme Court is the umpire. It makes the calls. It settles the questions of what belongs to whom. And McCulloch versus Maryland, for example, held that the national government is supreme over the states, and the states cannot tax the national government. And that is the end of this particular section.